Washington Legal Foundation. I'm Glenn Lammy. I am the Executive Director and Vice President for Legal Studies here at the Foundation. And thank you for joining us for this webinar. For those of you not familiar with the Foundation, we are in our 49th year of free enterprise legal advocacy and education. We file amicus briefs in federal and state courts, very active in the U.S. Supreme Court as amicus. We file regulatory comments, sometimes original litigation. And on our legal study side, we have publishing and we do programming such as this. If you're interested in learning more about us, please spend some time on our website when you have some time at WLF.org. So next Monday, the Supreme Court is going to hear oral arguments on a critical federal preemption issue. Each side is represented by top-notch appellate advocates, Paul Clement for Monsanto, Ashley Keller for Mr. Durnell. And we'll also get to hear from the United States. The court granted divided argument, and they will be speaking on Monsanto's side in this particular case. To help you prepare for that argument, we've assembled a panel of attorneys with expertise in appellate advocacy, preemption, and most important for this case, the FIFRA statute, whose uniformity clause is at issue. I will introduce our panelists, and then we will get started. Shannen Coffin chairs Steptoe LLP's appeals and advocacy practice. He frequently represents regulated businesses in the trial and appellate courts in matters involving commercial disputes, constitutional and administrative law challenges to government regulatory actions. He was counsel to Vice President Cheney in the Office of the Vice President of the United States. He's a member of Washington Legal Foundation's Legal Policy Advisory Board, and he authored an amicus brief for CropLife Trade Association in Durnell. Lawrence Ebner is Executive Vice President and General Counsel of Atlantic Legal Foundation and the founder of Capital Appellate Advocacy, a nationwide civil appellate litigation boutique located in Washington, D.C. Larry is a fellow of the American Academy of Appellate Lawyers and serves in leadership roles within DRI and the Federation of Defense and Corporate Counsel. And he is counsel of record in Atlantic Legal's amicus brief in Durnell. Willy J. is a partner in Goodwin Procter, LLP's appellate and Supreme Court litigation practice. He's a former assistant to the Solicitor General and a Supreme Court clerk. He has argued 19 cases before the Supreme Court and has briefed more than 65 Supreme Court cases on the merits. He clerked for Justice Antonin Scalia and Ninth Circuit Judge O'Scanlan. He is counsel of record on an amicus brief in Durnell representing that WLF joined, the U.S. Chamber of Commerce, the American Chemistry Council, Pharma, and the Product Liability Advisory Council. I want to let everybody know that we are recording this webinar. We will be taking questions. If you have any questions, please use the Q&A function that's in the Zoom webinar toolbar. So let's start off with a short history of the FIFRA preemption issue and a summary of the Supreme Court's last decision in this area, Bates versus AgroScience. Larry, this has been an area of practice for years throughout your career, so please grace us with some of your wisdom in this area.
Thank you, Glenn. FIFRA preemption of pesticide failure to warn claims is an issue that I've been thinking, writing, and arguing about for more than 40 years. And I guess the story starts in 1972 when Congress overhauled FIFRA and added Section 24B entitled Uniformity, the express preemption provision. It essentially prohibits states from imposing requirements for labeling or packaging of pesticides that are in addition to or different from requirements imposed under FIFRA. When it was enacted, nobody really thought that this express preemption provision extended to tort claims. In fact, in 1984, the D.C. Circuit in Farabee versus Chevron Chemical Company held in a personal injury case that 24B does not expressly or impliedly preempt failure to warn claims. That started to change in the late 1980s and early 1990s. And in fact, in 1991, I had the privilege of arguing what I think was the first Court of Appeals case. It was in the 11th Circuit, Pappas versus Upjohn, to hold that FIFRA impliedly preempts failure to warn claims because they would destroy the national labeling uniformity that the preemption provision is intended to achieve. Then in 1992, the Supreme Court in Cipollone versus Liggett Group, a cigarette labeling case, reaffirmed and articulated the basic principle that state law tort claims can impose requirements for federal preemption purposes. And that led between 1993 and 2005, a series of decisions holding that Section 24B expressly preempts failure to warn claims. I think by 2005, when Bates was decided, 9 federal circuits had squarely held there was express preemption, leaving the Furby DC Circuit from the 1980s as the only one that held there was no preemption. And during that period, a number of state Supreme Courts, notably California, also upheld preemption. Then came the Bates case in 2005, which is really a key case to consider because it was the first and only Supreme Court case to consider FIFRA preemption of failure to warn claims. I should say that between 1993 and Bates 2005, there was a bit of overreaching, I think, on the part of some members of the pesticide industry. Rather than limiting the arguments to preemption of failure to warn claims, there were arguments about preemption of strict liability claims, arguments about preemption of implied warranty claims. And so in 2005, when the Supreme Court decided Bates versus Dow AgroSciences, it made short work of those types of claims other than failure to warn, and held that they're not preempted. Before I briefly describe Bates, I want to say that, in my opinion, it was a poor vehicle for the Supreme Court to address FIFRA preemption of failure to warn claims, because it was an agricultural crop damage case, and it turned on the directions for use and warnings relating to efficacy of the herbicide product at issue. And because EPA has waived review of efficacy data, it's really quite different from the intensive way that EPA reviews toxicology and other health and safety data when it decides on a product-specific basis what warnings should be included on the pesticides label. So very briefly, Bates' opinion was written by Justice Stevens, and it held that pesticide failure to warn claims do impose state requirements for labeling within FIFRA Section 24B, and that the key issue as a result is whether a particular state failure to warn claim imposes requirements that are, quote, in addition to or different from, close quote, the requirements imposed under FIFRA. You might think that that phrase is quite broad. It is, in addition to or different from, but the opinion indicated that it's not all inclusive, because state requirements that are parallel to or genuinely equivalent to the federal requirements are not preempted. They're not in addition to or different from, but equivalent to. And it was fuzzy language in Bates, in my opinion, as to what that meant exactly. But right after Bates was decided, the plaintiffs' bar and several prominent anti-pesticide advocacy groups seized upon that implied exclusion from Section 24B, the parallel requirements exclusion or exception, and expanded it and convinced most courts of appeals for the last 21 years and most state appellate courts that if a state has a tort duty, that manufacturers have to provide adequate warnings on their labeling, which virtually every state does. That is parallel to FIFRA's general prohibition against distributing misbranded pesticides that don't have labels with adequate health and safety warnings, and therefore there's no preemption. Does not take into account the way EPA actually regulates pesticides on a product-by-product basis, and I'm sure that we'll be discussing that. So that brings us up to what happened in Bates and what's happened post-Bates during the past 21 years.
So you've watched the Supreme Court pass on several opportunities over the last couple of years to address this issue. So you obviously must have been pleased when Durnell was granted. Why now? Why this particular case?
Well, Durnell involves Roundup, which is the nation's and I believe the world's most widely used agricultural herbicide. And my understanding is that there have been more than 100,000 Roundup personal injury claims alleging that workers and others exposed to Roundup have developed cancer. And the theory of all of these claims is that the manufacturer, originally Monsanto, now Bayer, owned by Bayer, failed to provide a cancer warning on the label. Two reasons why I think the court took the Durnell case. First, there's now a split of authority in the Roundup litigation. The Ninth and 11th Circuit held no preemption. The Third Circuit in the Schaffner case held there is preemption, a failure to warn claims in the Roundup context particularly. And secondly, the Solicitor General supported review in this case.
So Shannen, could you talk a little bit about what the Missouri Appeals Court's rationale was on the issue of whether FIFRA and EPA's regulatory decision preempts the failure to warn claim? What's the argument? What are the arguments on that side?
Yeah. So and the Missouri Court of Appeals opinion, as you might expect from a state court, that's inundated with cases, is not the most heavily reasoned opinion. It sort of relies on the developed law in the circuits that Larry had mentioned. But essentially, in looking at the express preemption argument, the court said that the court compared Missouri's common law duty to warn with FIFRA's labeling requirements, and said essentially that they're the same thing. At a very, very high level of generality, the court said both state and federal law require a duty to warn, require that labels not be misleading, and to warn of environmental and health and safety requirements. And they essentially just looked at a very high level of generality at the components of the state strict duty to warn and the federal misbranding requirement, and said they essentially have the same purpose. What that overlooks is, and Bates says this, is that in thinking about these questions, you have to look at the regulations, not just the statutory provisions, but regulations which give teeth to the federal misbranding standards. And as a result, the Missouri court, following the Ninth Circuit and the 11th Circuit, focused only on the statute and didn't focus on how these labels come about. And the Third Circuit, in splitting from these other circuits, said you kind of have to drill down deeper. You have to drill down and look at how these labels happen, what regulatory provisions support the labels, and the process that gets you there. And if you look at that, a state that says you have to provide a duty to warn when EPA has said you don't, there's a much more obvious tension when you look at it at that level.
So, Willy, could you summarize for us Monsanto's argument that the state court's decision is incorrect? What are they asking the justices to rule here?
Absolutely. So they have multiple strings to their bow, and let me start first with the express preemption argument that is kind of their primary submission. And in a word, it is that the requirements under FIFRA include more than just the general don't sell misbranded products prohibition in the statute. So that the Missouri Court of Appeals said essentially, we are not different or in addition to, our state law is not different or in addition to, at the high level that Shannen described. And Monsanto's argument walks through what the requirements imposed by federal law really are, what the agency's role in that is, and why imposing a new warning just categorically is a problem. And then in a second, I'll get to aspects of this warning. But they start with the fact that you're not allowed to distribute a pesticide that has labeling substantially different from what EPA has approved. And that's the nub of their argument, that the federal requirements are more specific than just the overall obligation of the statute. And over the course of the briefing, there's some back and forth about what the preemption clause actually covers, but a lot of the emphasis is on the fact that it says under. It's not the requirements imposed by the statute. It's the requirements imposed under the statute. And both as a matter of how Congress drafts things as a matter of practice, and in the context of this statute in particular, there are lots of things that are under FIFRA that are not in FIFRA, and the things that the agency does in carrying out its regulatory duties to approve regulations, to approve labeling rather, and to enforce the regulatory requirements. Those are requirements under FIFRA. And so when you tell Monsanto, as a matter of state tort law and state common law duty, that you must, in order to be compliant with our law, have a different label with different requirements than the ones approved under federal law in order to be safe for Missouri purposes, you are doing exactly what the Supreme Court said in Bates and what Monsanto's sort of plain language reading of the preemption clause would both say, which is you're doing something that is different than the federal requirements. In a word, it's pesticide specific. It's not the 50,000-foot view that Shannen described. As I said, they have multiple strings to their bow, and they're also arguing implied preemption. And I know we'll get into that some more probably later in this program, but the basic idea being that even if the express preemption clause doesn't wipe out the state requirements, here what the state is requiring is something that is directly inconsistent with what federal law requires and would interfere with some important policies and objectives of the federal law, which include the ability to market a pesticide with the warnings that the EPA has approved and without warnings that EPA has specifically rejected. So why don't I stop there?
Thanks, Willy. So Shannen, Monsanto's brief, as does the brief you did for CropLife, reviews in pretty significant detail the registration process for pesticides under FIFRA and EPA's consideration of glyphosate, which is the substance in Roundup specifically. Can you summarize that process for us and explain why, sort of in this context of under FIFRA, why it's important for the court to understand that process?
Yeah, and thank you for giving me the most exciting question of the day. The register, as Willy mentioned, the registration process is an extensive one, especially when you're dealing with health and environmental effects. And you can't, as a basic matter, you can't market an unregistered pesticide. So you start with that that principle. And in order to register a pesticide, the EPA has to get the registrant has to provide the EPA with a ton of data about its effects on the environment and on human health. And the EPA makes a human health and environmental assessment. They also make a determination about what's supposed to be in the label. What the label has to include information necessary to provide adequate warnings for safe use and health warnings and environmental warnings. The EPA takes that data and does a very extensive review. And in this case, including toxicology and the effects, potential cancer effects of glyphosate, and that review in this process has involved hundreds of studies and well, not only an initial registration, but every 15 years thereafter, a registration review. Every time EPA has done that review, they've concluded that there's not sufficient evidence to conclude that there is a risk of cancer. Sometime in the 2010s, a WHO organization called IARC reached a hedged but contrary conclusion that there is some cancer risk. EPA looked at that in its registration review process here and said, we don't agree with it. We don't think it's scientifically backed. And this has been across multiple administrations, different parties. But once the EPA makes a determination about what's on the label, in this case, EPA said there doesn't have to be a cancer warning. The product, once is registered, can be used with the label approved by EPA. And in most cases, and I think this is key to the dispute, in most cases, except in very minor circumstances, any changes to a label that's been approved by the EPA, those changes themselves have to be approved. So you have to go back to the EPA and say, we found new data and we want to give a warning for a particular health effect. The EPA has to review that and sign off on it. There are some minor things that registrants can do to labels, but generally not precautionary statements about health and environmental effects.
So just to clarify here, Willy, you had said this in your comments about the Monsanto side. What's important here is not just the specific language of the provision in FIFRA, but also what the agency's determination is as to the ingredient in Roundup, correct?
That's right. I mean, so I would say Monsanto has an argument that would be broadly applicable to any attempt by a state to change the warnings. It has arguments that would be applicable to any attempt to change the Roundup warnings because of the approval process. And it has a very specific argument that as Shannen was just outlining, the specific warning that the state tort law wants here would be contrary to federal determinations and be preempted for that reason, even if none of the other arguments were valid.
Okay. So Durnell and the Missouri court disagree with that. They argue that what matters is FIFRA's sort of broader general purpose, warn users of potential risks to health and safety. Larry, what's the counter argument to that line of reasoning?
Well, first of all, some courts think the issue about preemption in general is whether state law should be preempted. That is not the issue. The question is whether it is preempted, not whether, as a matter of policy, it should be preempted. And of course, the should be preempted question, there was fertile ground for activist judges, whereas, again, the question is whether it is preempted, either expressly or impliedly. As all of us have said during this discussion, the key here is the way that EPA actually regulates a particular pesticide's label specifically which warnings should or should not be included. And the should not be question is important because if you have too many warnings, there'll be overwarning, and the warnings that really do matter will be lost in a sea of unnecessary or unwarranted warnings. So 2 points. First, Bates itself hints by referring to EPA's regulations that it's not just a question of what the general prohibition against distributing a misbranded pesticide requires. And in fact, I think it was Justice Breyer's concurring opinion in Bates that further emphasizes the importance of EPA regulations. Now, EPA does in fact have a set of baseline labeling regulations, 40 CFR Part 156, but they are just the baseline. And again, the real question is, what has EPA determined after review of scientific data the warnings should be for a particular product? The other point I want to make is that I think in Roundup, the case for preemption, express preemption, is particularly compelling because EPA did not merely determine that a cancer warning was not required. It went one step further and notified registrants of glyphosate, which is the active ingredient in Roundup agricultural products, that putting a cancer warning on the labeling would be false and misleading and a violation of FIFRA. So the very same multi-part definition of misbranded that the plaintiffs rely on to support their preemption argument is also the misbranding provision that EPA has cited and invoked to inform registrants that they be violating federal law by putting a cancer warning on the label, the very same cancer warning that the plaintiffs say is the basis for their failure to warn claims. So I think that makes this case particularly interesting and compelling from a factual viewpoint.
Thank you, Larry. Shannen, one of the other arguments that plaintiffs have made and courts have sometimes accepted is that there's a miscellaneous section of FIFRA which says that registration of a product should not be construed as a defense for an offense under the statute. What are your thoughts on that argument?
Well, we broke that down in CropLife's Amicus brief, and Paul Clement has done so in his merits brief. That provision really says nothing about preemption. It is a vestige of an old regulatory system. It was in the original FIFRA in the 1940s, before there was an express preemption provision. The express preemption provision was added in the 1970s. In the original system, EPA had to, the regulator at that point, the federal agency in charge, had to register a pesticide, even when it had reservations about health and environmental effects. That is to say, there was a protest registration process that allowed registration to go forward, even in the absence of support from the federal government. And in those circumstances, it makes a bit more sense to say, well, the fact that you've got a registration is not a defense to any violation of the act. But this provision really had nothing to do with preemption. The Third Circuit actually looked at this point in its decision and said, maybe that provision has just lost some of its force. It doesn't speak to preemption at all, and while it does mean that the mere fact of registration is only prima facie evidence of compliance, it wasn't meant to have an effect on whether state law should apply.
So Larry, circling back to what you were talking about with regards to parallel regulation, what things can states do regarding pesticide regulation, either through regulation or state law claims under FIFRA that wouldn't be preempted pretty clearly?
Well, we've been discussing Section 24B, which is titled Uniformity. Section 24A says that states can regulate the sale and use of pesticides, even though Section 24B says states cannot impose their own additional or different requirements for labeling. So, for example, under Section 24A, a state can disagree with EPA's determination about the safety of a pesticide product and decide not to register the pesticide for use in a particular state or cancel the state registration for the use. So in that sense, a state can second guess EPA's determination as to whether the product is safe enough to be used within a particular state. In addition, FIFRA gives states what we call the primary enforcement authority for pesticide use violations. One of the prohibited acts under FIFRA is using a pesticide in a manner inconsistent with its labeling. That goes to the users of pesticides, not the producers of pesticides. And states have the primary authority to identify and enforce violations of label directions. But again, states cannot regulate the content. So let me go back to the parallel requirements exception that I mentioned earlier, because I believe that the plaintiff's bar has distorted and expanded beyond recognition that narrow exception in terms of state tort law. And the courts, until now, most of them have bought into that misinterpretation. So the best way I can explain what the parallel requirements exception really means is by going back to Bates. And when you read Bates carefully, it says that states can have their own remedies for violation of federal labeling requirements. So, for example, let's just say hypothetically, EPA had determined, contrary to the fact, that Roundup labels needed to include a cancer warning. And a manufacturer of any product containing glyphosate, not necessarily Monsanto, for whatever reason, distributed the product without the cancer warning that EPA said needed to be on the label. Well, FIFRA does not have a private right of action. So I believe the parallel requirements exception means is that under those circumstances, if a user of a glyphosate-containing product said that he developed cancer because of the absence of a cancer warning that EPA required, but the manufacturer didn't include, I don't think that would be preempted, because that would be based on a parallel requirement and a failure to comply with the federal requirement for such a warning. That can apply to other types of health and safety warnings, for example, required personal protective equipment for farm workers. So I think that's what the parallel requirements exception really means. It only applies in the narrow, rare circumstances, very rare circumstances, where a pesticide producer does not adhere to the specific warning requirements that EPA has determined apply to a particular products or a particular active ingredients labeling.
Thank you, Larry. So let's do a couple of questions on the sort of potential broader implications of this case for the preemption principle and jurisprudence area. So, Willy, the brief that you did for the Chamber, WLF, and some other groups urged the court to clarify that a so-called presumption against preemption does not apply to statutes that have express preemption clauses like FIFRA. Can you explain what the presumption against preemption concept is and why it's important for the court to be clear on that here?
So my snide webinar line is that the presumption against preemption is strict constructionism for plaintiffs' lawyers. It is the idea that Congress probably did not mean to oust state law in an area where the states have historically regulated. And so we should read federal statutes with that presumption in mind, and sometimes even really require Congress to jump through hoops, to use magic words, to, essentially pat its head and rub its tummy in exactly the right way before giving the language of the statute a reading that would push aside state law. So just like Justice Scalia used to say, I am not a strict constructionist, I am a constructionist. I believe that the words that Congress enacted have their ordinary meaning and we should give effect to them and not say as judges, well, I don't agree with what Congress did, or I'm going to require Congress to tell me twice or three times before I will give effect to the ordinary meaning. This is an area where the court has finally started to clean up its doctrine. Starting a few years ago in one of the Puerto Rico bankruptcy cases, the court basically said an express preemption clause is a part of a statute and it should be read like any other part of any other statute. The words have the ordinary meaning, and if the ordinary meaning is that federal law pushes aside some state law, or I should be a little more precise, that federal law has a meaning that conflicts with what states might prefer the law to be, or whether as a matter of common law or state law, well, them's the breaks, because we have the supremacy clause in our Constitution, and when there is a conflict between federal law and state law, federal law is supposed to win. And reading Congress to be so afraid of deploying its power that it would shrink from a conflict with state law is not the right way to read statutes. Now, we can come back to this same topic when we get to implied preemption, but express preemption is just giving effect to the meaning of a statute, and a preemption clause is a clause, and a clause is part of a statute.
Thank you. Shannen, in the process of refuting Monsanto's arguments that some of the court's past express preemption precedents apply here, they really home in on one specific case involving medical devices and the Medical Device Act, Medtronic versus Regal. Can you talk a little bit about how that case may apply in this particular case, even though it doesn't involve medical devices?
Yeah, and the lower court, the Missouri Court of Appeals, just distinguished Regal by saying, well, that involves medical devices.
Right.
But the principles in that case, I think, are very powerful here. The Medical Device Act had a similar scheme and a very, very close, in addition to preemption clause. But the Medical Device Act required this registration process, and when a medical device was registered, you had to go back to the FDA to get any changes in design or labeling. And the court found that process, crowded out state law because a state tort law couldn't come in and require things that the FDA hadn't approved yet. And you see that same sort of theme working out in some implied preemption cases as well. But the regulatory process was very similar to what's at issue here. And that is, the Third Circuit, in splitting from its sister circuits, really honed in on that lock-in. That is to say, when the EPA has made a labeling determination, except in these minor circumstances, you have to go back to the EPA to get a modification to the label. And that was the same process that was at issue under the Medical Device Act, which the court found was enough to give teeth to an express preemption provision very much like this. We think it's on all fours. Yeah, Larry.
Glenn, if I could just add something. I mean, this whole discussion about express preemption provisions, particularly those like FIFRA and the medical device amendments that expressly preempt state requirements that are in addition to or different from state requirements, raises an interesting question about if Congress really wants to preempt state requirements on a particular subject, how should it do that? And I think Congress, for a long time, assumed, well, if you have broad language like we're going to preempt any state requirement that's in addition to or different from a federal requirement, I mean, what more is there? So we go back to, Bates and Regal, which says, well, what else there is are equivalent requirements. So maybe if Congress in the future, really wants to make it crystal clear that it's preempting all state requirements, it should use even broader language and say something like no state shall impose a requirement relating to pesticide labeling or requirements for labeling under FIFRA or medical device labeling. The Supreme Court, as recently as last week in an unrelated decision, has emphasized the expansive meaning of the phrase relating to, which is a very common phrase in federal statutes. So I'm kind of adding that to your question about the broader implications of the FIFRA preemption issue.
Glenn, the plaintiffs try to deal with this problem by mischaracterizing what the regs say. They say, well, this is the sort of label change. We can make a cancer warning change without a notification process, by simply telling the FDA we're going to do that, and FDA doesn't have to approve. So this isn't at all like the medical device amendments provisions at issue in the other cases. But it's just not right. And I think that Monsanto's done a very effective job of picking that apart. The regulatory provisions say that if there's health and environmental aspects of the label, they have to be reapproved by FDA, by EPA. Sorry.
So, Willy, how do you think a decision in Durnell is going to impact the larger doctrine of federal preemption, at least in the express context? Are other federal statutes like FIFRA in their use of express preemption?
There are a number of other statutes, often those that involve labeling, because in our national market, there's this real value to being able to know that you can sell the same product with a single label across the country. Like it's one thing for a soda can to say 5 cents in Indiana, 10 cents in Michigan, for a bottle deposit refund. But it's quite another for a pesticide with all of the text that it has to include to have 51 different warnings, potentially local warnings as well, based on where it's sold. So there are a number of statutes governing everything from meat to pesticides that involve things like this, that involve requirements different from or in addition to the federal ones. And accepting the respondents' broadest position, which is that nothing the agency does matters, because ultimately it's always up to the courts to decide what is misbranded. And therefore, the only prohibition is what a federal court might read the statute to be. That would mean that the entire regulatory framework that allows these products to gain approval by an agency would be out the window for purposes of preemption. And you really would have not just state license to legislate, but state license to litigate and impose after the fact warning requirements by jury. And that would be true. It would be just as true of like packaged meat or a defibrillator as it would for a pesticide.
If I can just put it differently, Willie, I mean, what's the sense of having expert federal agencies like EPA or FDA that review scientific data and based on those reviews make regulatory determinations, including about label warnings, if any jury in any state can undermine those determinations through tort law?
Right. And the question that just popped up in the chat, actually, which is about Loper-Bright, is an attempt to key off of what Larry just said and say, essentially, it's a brave new world. Chevron is gone. Agencies are irrelevant. And so who cares what the agency thinks is necessary to avoid the product being misbranded? That's the agency's view, but, a judge in a federal court might disagree. But the key problem is that you can't market certain regulated products, including this one, without going through the registration process. In other words, like you can't sort of say to the EPA, thanks for your view, I'll take my chances in federal court with the judge. Like the fact that you don't have registration is the problem. You can't market without complying with registration. And as a result, you can't market a product that's substantially different than the registration you obtain. That's why
right. And the label
regulated products.
Sorry, Shannen, what was that?
And the labeling decision is all part of that. So, the Loper-Bright argument is sort of a misfit for it. It really is an attempt to try to fit this in, the brave new world, but it's a misfit.
So, Larry, as I had mentioned at the outset, the U.S. government has been given some argument time here, and obviously they filed a brief in support of certiorari and in support of Monsanto at the merit stage. How much of an impact do you think its position and its involvement to this extent are going to have on the outcome here?
Well, I'd mostly like to defer to Willy on that question, since he was an appellate advocate for the government. But let me just say that I think it will have a significant impact. And one thing that we know that in our Amicus brief is that the government over the years has changed its position on fit for preemption a number of times. I remember more than 25 years ago arguing fit for preemption before the California Supreme Court, and a Justice Department lawyer was on the other side of the aisle arguing against preemption. And I've lost count, but maybe 4 different times the government has changed its position, pretty much based on which political party was in the White House and how much influence the plaintiffs' bar had on the administration that was in office at the time. But Willy, you probably have a more insightful answer about how important the government's views are going to be here.
I mean, I don't know if it'll be insightful, right? But I was a law clerk at the time of Bates, and the government came in support of affirmance, like the pro-preemption position in that case, and the court did not fully adopt their position in that case. And since then, as you say, like by flipping positions, the government tends to create opportunities for justices who are skeptical especially skeptical on the merits, to say, but didn't you say the opposite to us or to some other court 5 minutes ago? I do, and I would just add one more thing.
I think that happened during the Bates argument, as a matter of fact.
Right. I think Lisa Blatt has lost very few cases in her career, and I think that might have been the only one for a long time. I think she would say it was not her fault. The other thing I was going to add is that I think that the justice most difficult to get on these issues might well be Justice Gorsuch, who does not care what the government's position is. If anything, might like the fact that it's the government's position might be a minus and not a plus. But the current administration, I think, has been not your typical administration in the sense of many executive branches of both parties have predictably taken the position that gives the executive branch of the federal government the most power. This administration, especially during Loper Bright itself, has had a more nuanced view of federal law, especially federal agency power, and their ability to come in and say essentially, yeah, we agree with and understand Loper Bright, but this is why that has nothing to do with the regulatory role of the agencies under this statute and those like it. I think they have more credibility to say that.
And really, we're only talking about regulations that say, you have to come back to us if you want to change the label. So this isn't some extreme interpretation. The statute requires the agency to make a labeling determination as part of registration, and the agency is saying, okay, once we make that, we want to clear any changes too. Science may change, that's correct, but we need to evaluate that. And I don't see anything remotely offensive about that sort of notion to a Loper Bright world.
So, and interestingly, right, so in the preemption decision that about the regulatory framework that governs generic drugs, the government took the position in that case that state tort law was not preempted. But it did explain, just like what Shannen just said, that a generic drug maker that wanted to change its label could not simply just change its label, because generics have to mirror the brand name equivalence labeling. And the Supreme Court, in deciding the case, agreed with the government's explanation of how agency procedure works. In other words, you can't just do this by saying so unilaterally, you need permission. And then said, but the government gets to the wrong conclusion. So they disagreed with the government on the preemption question while agreeing with the government about how the regulatory framework works in practice. And so the takeaway from that is the agency's explanation of how their own frameworks work and what you have permission to do under the law and what you don't have permission to do under the law actually does get more deference even from justices who might otherwise be skeptical of agencies.
And on that point, just think about a world in which a pesticide producer is allowed to add to its product label warnings about every conceivable risk without having to get EPA's prior approval. A manufacturer might want to do that to avoid the risk of being sued for failure to warn. And if you have a label like that, think about some of the, I'm not that familiar with FDA regulation of warnings, but think about the package inserts on prescription drugs or the TV ads you see. If you have a pesticide label with a zillion different warnings, how is the user supposed to know the ones that really matter? The ones that EPA really has evaluated from a scientific viewpoint and has determined are necessary. How would you be able to differentiate those than just warnings the manufacturer is putting on the label to avoid the risk of liability for not putting it on the label? That's a good reason for courts to enforce the FIFA preemption provision.
So Willy mentioned Justice Gorsuch with regards to what the government's position is. Shannen, what's your sense of other justices for people to watch when they're listening to this argument on the issue of preemption. Justice Thomas has sometimes been a little bit hard to pin down in terms of where he is on preemption, especially the implied preemption, but express maybe a little bit more so. But what are your thoughts on what people should look for?
The Democratic appointees are generally skeptical of preemption and rely on presumptions and try to read statutes pretty tightly to allow state law to go through. And I think that's probably going to be in play here. It's the sort of thing that the sort of permissive attitude you saw in Bates 20 years ago. Justice Thomas is always interesting. And today's opinion in the government contractors preemption case, suggests that he continues to be skeptical of certain implied theories, especially non-direct conflict theories, purposive preemption. But the one area that he's strongest on is express preemption. Back to Willy's point that he made so masterfully in his chamber brief. The court has, in recent years, gotten to a point where they tend to say when it's a statute at issue, when there's statutory express preemption, we're not going to put a thumb on the scale. That was Justice Thomas's position in Bates, and the majority said differently. But Justice Thomas's position in 2005 gathered steam, and then one of the Puerto Rico finance cases, became a majority position. And so this is one area we know what Justice Thomas's views are, because he wrote a separate concurring and dissenting opinion in Bates. I think this does break down ideologically, not necessarily politically, but ideologically, where the conservatives on the court are much more skeptical of state law and much more willing to find federal preemption, especially where Congress has provided for it. I think Willy mentioned Gorsuch. Gorsuch is his own animal, to use an impolite term, I guess, but endearingly so. This will be, a textual test for him, I think.
Yeah, I mean, he had that Virginia uranium case in which I think he was, quite sympathetic to state law, even in the face of statutory express preemption. The one thing I'll say about the Democratic appointees is that there's a thin layer of stare decisis here, and also an opportunity to say things about Loper-Bright. My guess is that the things that they would say about Loper-Bright, partly for the reason that Shannen gives, is sort of, you sowed the wind and now you must reap the whirlwind. We would have happily kept Loper-Bright, but it's gone. We would have happily kept Chevron, but it's gone. But to the extent that the respondent's position requires overturning a whole bunch of preemption precedent, statutory preemption precedent, Justice Kagan has that oft-quoted Spider-Man opinion about superpowered stare decisis in the statutory context, and it might, conceivably that might make an appearance.
On the other hand, Bates can be readily limited, and because, as Larry was talking about at the very beginning, Bates involved a situation where the agency didn't really review the efficacy data at all. The court made that point many times in its opinion. And this is just a different circumstance where there's extensive review of hundreds of studies over many years, and the agency keeps coming to the same conclusion.
I think that this case The Durnell case is one that even Justice Thomas would accept is a good case for impossibility preemption, which is one form of implied preemption. How could you not have impossibility preemption? In other words, how could you not have a situation where it's impossible to comply with both state law and federal law when EPA says you'd be violating federal law by putting on your label the very cancer warning that the plaintiffs say is required under state tort law? That puts literally puts the producers into an impossible situation. And although Justice Thomas is skeptical, in fact, I think he is categorically opposed to obstacle and purposes preemption, he's not opposed, I don't think, to impossibility.
That's right.
Preemption, which has been argued by Monsanto, so that even if for some reason there were no express preemption, I think the court would probably want to consider implied preemption and particularly impossibility preemption, at least under the facts concerning Roundup.
Willy, do you think there are going to be questions about implied preemption in this argument at all?
Possibly, but that's in part driven by the court's argument format, which allows the justices, especially when they feel like they're getting their questions answered, to ask as many questions as they want, and limited only by their desire to adjourn and go to lunch. But I do think that a number of the justices, especially in the sort of bonus round seriatim questioning at the end, do like to make sure that every major topic has been touched on if there are any questions about it at all. So, in other words, it wouldn't surprise me to hear some questions about implied preemption, but I wouldn't read that as a sign that the justices are leaning away from deciding express preemption.
This might be a good point for me to give a shout out to Monsanto's reply brief, authored by Paul Clement and his colleagues. It's an excellent brief, and it covers virtually every argument that Mr. Durnell raises in opposing preemption, express and implied preemption. It's an excellent brief, and I commend it to anyone who wants to just read a terrific reply brief.
So for anyone who may not be familiar with the argument process, Willy, how much time is Monsanto going to have as compared to how much time is the U.S. government going to have? Like, is the U.S. government's time going to cut into Monsanto's argument time, I guess, is the basic point.
That's right. So each side of the case shares half of the hour. So Monsanto and the government together will have 30 minutes, Monsanto 20, the government 10. But each of those two lawyers gets a bonus round. And so in practice, the side with two lawyers sometimes occupies more sort of time on the stopwatch than the side with one lawyer. So
the U.S. government has rebuttal time as well as Monsanto's lawyer.
Not rebuttal time, but by a bonus round, I mean that once the 10 minutes expires, then the Chief Justice will recognize all the other justices for an untimed round.
Oh, right.
If they want to use it. And often in complex regulatory cases where the deputy SG is an experienced advocate who also knows the regulatory stuff backwards and forwards, often they keep the government lawyer up there for a while.
I want to thank everyone. We've reached our witching hour here at 2 o'clock. We got over, I think, an enormous amount of information and discussion and insights. And hopefully everyone who tuned in today had an opportunity to learn something along the way and help prepare them for the arguments. Shannen, Larry, Willy, thanks so much for the time.
Thank you, Glenn.
As I noted at the outset, if anybody came in late or if you'd like to see it again or share it with someone, this will be available on WLF's website a little bit later this afternoon and also on our YouTube page. Thanks again for everybody for joining us.